currently, it's clear that the city attorney is not being engaged in all ongoing litigation that occurs on behalf of the city. And that's what spurred this resolution. The information I'm about to share is based on a publicly available docket that is posted on the Northern District of New York Federal Court website. I invite you all to go see it. It's called PACER, which is the Public Access to Court Electronic Record. So nothing I am saying isn't a public record. It's not private, privileged, or otherwise non-disclosable. But it illustrates why this resolution is so important, that we have the city attorney be in coordination with the Director of Risk and Safety. On April 1st, 2022, a member of the City Council, without any authorization by any other members of the City Council or involvement of the specific department that was being sued by a former employee, met with the Director of Risk and Safety and attended a settlement conference in a years-long litigation matter before the U.S. District Court of the Northern District of New York, without informing, prior to the hearing, any city council member or bringing the city attorney into the discussions. Based on the docket of the Federal District Court, it seems apparent that a settlement conference was held and negotiations ensued. Now, based on the publicly available docket in this litigation, it appears that another critical date is about to come up in this case. On or about July 7th, 2020, the city will need to take action on this litigation to ask the court to discuss the matter. In the way I read the charter, the city attorney's office should be involved in that discussion. It has not been involved at this point. It's imperative that we as a city council make sure that no litigation is handled or resolved without the involvement of the city attorney and or the other members of the city council who would have to approve any final disposition as required by the charter. Under the current structure, in which the Director of Risk and Safety works directly for the Department of Accounts and not the city attorney, we open the city to substantial risk, as shown by the example above, where a city council member with a Director of Risk and Safety attempted to resolve a legal matter without involving the city attorney's office, any member of this city council, or the specific department that was the subject of the litigation that was now being discussed in the Northern District of New York before a magistrate.
Bring it up with a council member.
I'm sorry, there is no public comment at this point. So the reason that it is imperative that the city council act, I believe, and also do it now, is because if we don't, this case will continue to go forward without the involvement of the city attorneys. And that is not tenable, both from a charter standpoint and also good legal practice would require that the city attorney's office be involved. So that's why I bring this motion forward. I've got a second. I don't know if there's any comments or questions on the resolution.